today. That's not a reason for me not to have things done because there was COVID. You did not respond to 2009 issues by the AG because of the COVID period that happened 10 years after the audit outcome. Chairperson, which system is actually working in the department? Because when we were dealing with the licensings, I forget the acronym that they use. They said their system database was not working due to, I don't know, whatever reason. I can't recall because I don't have my notebook with me. Again, with the derelict and ownerless mine, the system is not equipped to deal with the database. Babumpele, iyiphi system yena esebenzayo kahle kahle ku-department. Chairperson, on the issue ye MACUA and WAMUA, I hear DDG Makubela saying that they have most prominent companies have 50% employment of HDSA, have employment of women in top positions. But Chair, I failed to get him or hear him talking about local beneficiation. You see, when people are talking about local beneficiation in a mining company that is mining in their area, it means that the people in the locality where the mine is operating, they are being employed, they are being skilled. I did not hear his explanation on that one. What's my other point? And Chair, okay, let me stop there for now, Chairperson, because I can't see to find my and if the last one, Chair, clarity, Mr. Makubela. If you dispute that MPRDA has failed to deal with illicit and illegal mining, if you can get clarity there, given the state that the mining or the muscle that the illegal mining is happening, is MPRDA equipped to deal with the challenge that we are faced with of illegal mining? Thank you very much, Chair.
Remember, Dogger, continue. I'll come later after you are done.
Thank you, Chair. Because of network problems, I did not know the sequence. My apologies for being quiet. I was waiting until everyone speaks. But nonetheless, I welcome the report under serious duress, by the way, in the sense that we have, I would like to think that this is something also we've raised a number of times, the time in which these presentations are sent to us, and that we never get enough time to actually prepare. So I think that even these ones, they were sent around 12:30 yesterday, which is outside the 24-hour framework. And I do not think that it is fair that we keep saying and we keep making the same request to the department that they give us presentations on time so that we can actually thoroughly go through them. But nonetheless, because these are contents, or perhaps this is work that we have done and it's quite fresh in our minds because we've engaged both the Human Rights Commission and AXA recently. But I think it's something that, Chair, we really need to look into. We can't keep saying the same thing, that presentations must be available on time, and that does not happen. Secondly, my biggest issue, and I think perhaps it's adding on to what Ume Malinga is saying, that the issue of excuses and us being told about COVID-19 does not make sense. And over and above that, there seems to be no accountability, none whatsoever, in terms of the department, and in terms of them actually owning up to things not being done. It's always COVID-19, it's always a lack of resources, it's always systems that are not working, but they are the custodians of all these things, which therefore means if a system is not working, you are yourself responsible for those systems, which therefore means that you are not doing the work. And my biggest worry and frustration is that as well, that we are going to keep saying the same thing or raising the same issues that we're not happy with how things are done by the department. But because there will be no consequences, that we're going to get the same thing over and over again. And I think to a certain extent, there needs to really be like much more vigorous and much more stronger responses to how things are being done and how we're even getting even the responses that we're getting. But nonetheless, I think the questions that I have are on all the reports. The first one being on the one of the Human Rights Commission. And I'm interested in the fact, I think that the report was available in 2014. And I'm interested in when the department has actually started processing the report and whether there has been some sort of a bilateral conversation or a meeting between the DMRE and the Human Rights Commission so that they can find each other, because by the look of things, it looks like both these entities, if I may put it that way, are speaking past each other about the same thing. And I think one other question I want to understand, and I think I asked it in the previous meeting as well, is I would like to understand that the report is speaking about unregulated artisanal mining, which is mining that has not been licensed, mining that is not monitored, mining that is not regulated, which would essentially be illegal mining. So I'm trying to understand what is the fundamental difference between illegal mining and unregulated artisanal mining, which the report is speaking about, and what is the difference between a zamazama and an illegal miner. Because I think I get confused quite a lot in terms of that conversation and those definitions, which in my view, it's basically the same thing, but it does not seem to be the case. Another question I have is about this National Coordinating Strategic Management Team on Illegal Mining. Who are they? Who do they account to? What is their role in this whole conversation? I do not think that I received the response when I asked the Human Rights Commission. Perhaps the department can respond to that. And if we have such a coordinating structure, why are we still sitting with all these problems in relation to illegal mining, and who is engaging them? When do we actually even engage them, even ourselves? And I think the issue of building profiles of the zamazamas and the people who are the value chains and all those things, as much as I think the report speaks about that, it is the responsibility of the law enforcement. So I'm interested in whether the SAPS has confirmed themselves that that is their responsibility, or we are assuming. And secondly, I would like to understand, because I know that Mintech at one point did say that, look, we can assist the police in terms of training them, because the police were saying, look, we don't know a lot of things about mining and all these things, and we do need assistance. And Mintech was saying, look, we have the research, we have knowledge about how mining works, we have research about all the places where illegal mining is happening and all these things. And I'm trying to understand, when then the department says it's a responsibility of law enforcement, does that not mean that the research and also the hand that Mintech has stretched to actually assist, does it not get considered by the department? And then I think with the issue of MACUA as well, I understand that the tone of the organizations, which is both of them, has been extremely problematic and questionable. But we cannot negate the fact that most of the issues that they are raising, they are genuine issues that have not only been raised by themselves, but various other communities, even unorganized communities. Even when people go on oversight, we're getting the same issues. When we're having public hearings, for instance, some people were not even speaking about gas amendment bills. They were raising some of the issues that MACUA has been raising or are raising. And I would have expected the department to a certain extent to sort of sift the issues and actually work on responding on the genuine issues that are being responded to. And also the issue of us saying that the MRDPA does not have any shortcomings or is working really well according to what we're told today. But at the same time, we are everywhere we were interacting with mining communities. They'll say the same thing, that we're not benefiting from these mines. And I think that the tragedy in Jagersfontein is one that should have actually, even ourselves, even if we believed that they were, it should have raised some alarm bells, because the one thing these people say, it's been decades. It's been decades we've spoken to practically everyone. We've submitted memorandums, and we've been saying that we've not been benefiting from this mine. And this is happening across board. And there's really not been any intervention from the department to ensure and to enforce these mining companies to make sure that they assist our people. And that is a very genuine thing that I think that the department, to a certain extent, should at least be telling us about what then becomes the way forward. And I think on the report of the AGSA, if memory serves me correct, they were saying that the National Mine Closure Strategy was 11 years overdue, which I found very alarming and problematic, especially considering the fact that the rehabilitation and closure of mines is something that is extremely urgent and important to us. So I'm trying to understand what was the delay, because we did not have COVID-19 until maybe 2-3 years ago. Why did we not have a strategy until then? And if we're only going to start effecting the strategy in the 2022-2023 year, what has the department been doing throughout? What strategy, what has been informing your response to mine closures and rehabilitation? The second one is on the mine database. I understand that you are saying that the database is currently being updated, but I'm interested in what is the expected completion date of that update. And why I'm asking this as well, perhaps, is to understand as well that maybe we might have even underestimated the number of mines that need to be closed and the amount of work that needs to be done, which therefore means that to a certain extent might affect the budget and also even the years, because we're already now speaking about 2043 and so many years, which is very far from us. So I'm trying to understand that with the database that we have currently, are we still within the projections that we have, or do we feel that we have underestimated the work that we might have to do with mining rehabilitation? I think what the department also raised was the issue that they were not able to perform some tasks or do some things because they do not have human resources. They're not able to do monitoring. They're not able to do a lot of things because of that. And I think we also raised this issue of vacancies in the department that stand or that are there for a very long time, and there's no address to that. So I'm interested in whether, when you're speaking about these human resources, is it also the vacancies that we've been told about? And if not, are we also in working on maybe increasing the human resource element in the department so as to meet the targets that are there? Because the reality is that we can't run away from the fact that South Africa has high unemployment, and therefore it cannot be that we're sitting and we're saying that we do not have resources, but people are sitting at home without jobs. And this is actually work that needs to be done, and it is urgent. And I think what I need to also understand is just generally on derelict and ownerless mines, because we've also found out that some people would close mines, some would just disappear, but they would still go and continue operating new mines. I think this is what happens even in Krugersdorp, where some of the people were in the management and who were owners of the mine that had applied for business rescue are still active in the mining industry, and they are still getting profits. So I'm interested in whether the department has considered doing like some sort of a profile of tracking what is the current activity of the owners or the management of the mines that were having problems with. And if those people are still active in the mining industry, whether it is South Africa or not, then are we not then able to actually compel these people to now go and close the mines? Understanding as well that we do get a response that there was no legislation before compelling people. But I think even the Jagersfontein tragedy has opened our eyes. And in fact, it has proven that some of the people, even though there is legislation, they are still doing as they please. And I think that is also confirmed by the fact that the department has confirmed that they are not monitoring as much as they should. So what then happens to the people who defaulted or people who still did not adhere to the legislation even after it was passed, and then they abandoned the mines or they disappeared or they closed the mines and they are still active in the mining industry in South Africa? So what then becomes the role of the department? Are we profiling the people that owned these mines? Where are they? And is there a plan to compel them to actually take up some of the costs of rehabilitating and closing? Thank you very much, Chairperson.
No, thanks, Chairperson, and my greetings to your good selves, the colleague, honorable members, the department, and all the other participants on the platform. Chairperson, I am going to be very, very brief, seeing that it looks like Honorable Madokwe had a caucus with me. She covered a lot of other issues, including Honorable Malinga. But Chairperson, let me start with the presentation that was done by DDG Makubela. And then the gist of that presentation was more about the Human Rights Commission and the department with regard to artisanal mining versus illegal mining, or the zamazamas. There seems to be a different understanding from both the department and the Human Rights Commission, or a lack of understanding, vice versa. I just wanted to check with the department, in their engagement so far, have they found common ground? What would their take be? Have they found common ground on that understanding, so that in future when we have a report, we read the report from the same understanding, so that even the interventions are guided by the understanding that comes from there. There's one clarity that I would want to find out. Have they reached some sort of understanding on a way forward? Secondly, Chair, on slide number 9, and it has been touched by Honorable Madogwe as well, there's recommendations. There's recommendation number 4 that deals with the profiling of the zamazamas and so on. Now, this from the department side, the department says, all right, we hear what you are saying, Human Rights Commission, but that is not our job. It is with the law enforcement agencies. I beg to differ, and I would like them to, in their recommendation, I mean, in the way forward, as per the recommendations or the observations, look in terms of when we went to the different areas for site visits and so on, including the disaster that we went into. There's always been something like a joke or a joint meeting and so on. And I would prefer the department to accept that whilst the law enforcement is good at profiling, there is a need for the department also to do that profiling, because they would know where the setup is, they would know what is happening, including we've got inspectors from the Mine Health and Safety, we've got inspectors within the department. So there is a need to really look at the take from the department, so that we don't just kick the can downwards to profiling, and as far as SAPS law enforcement is concerned, but it's a joint effort of profiling both the zamazamas and the territory, that is at question. And then on the AG's report, also there's a slide on most of the slides. The AG has raised certain issues, and then the department has undertaken to do remedial or further work on what has been identified or brought out by the AG. But I'm not happy with a lot of noting where the department just notes what the AG has said, but they don't give us an idea of what they are going to do. Yes, of course, there are comments that can just be noted, but other issues cannot just be left for noting. So there's a number of them. For example, there's where they note that the AG's findings and the negative effects raised by illegal mining and so on. And they just note that without saying, all right, this is what we anticipate happening, or this is also what we are going to do. So I'm concerned about just the noting. Chair, there's lastly, in general terms, there's a report that Mintech and the department also submitted at some stage with regard to mine closure and rehabilitation and the good work that Mintech has done, especially on the asbestos part of the mines. And it also tells us with the current budget, how long it's going to take. The minister also alluded to that. So it is actually in our reports and in our understanding. I want to find out what would the department, what's the department's thinking with regards to, you have asbestos mines on the site, and I have heard little, if no, except for health issues with regard to zamazamas, with regard to violent crimes and so on, around this derelict or ownerless mines, asbestos. But where you have a lot of problems, as we speak now, it's around mostly your gold mines or your disused gold mines. And if the funds, is there a possibility of redirecting the funds for now to deal with the crisis? Because I don't really think the asbestos part of it, if they have not finished it by now, if we can get the funds, transfer some of the funds, if not all of the funds, and deal with this immediate problem that finds itself mostly around the West Rand, going through to the East Rand. So I just wanted to find out what is the department's take with such a proposition in terms of prioritizing, so that we can finish off one of these twin problems that we have. Thanks, Chairperson.
Thank you, thank you, honorable members. If it was not a lot, and I will tell you why, DG, if it was not this so loaded, it's not even questions, it's an input. I would be putting my own. But let me first give you DG and your team to respond on the comments as well as the questions that we're seeking clarity.
No, thanks, Chair. We will endeavor to respond to all the questions that were raised and the comments that have been raised. Maybe from my side, let me pick on some of the comments that were raised and already respond to them before I give to the colleagues to go into the details on some of the comments. Chair, I think the first point, which was a comment, is around the COVID as an excuse. I think from my side, I agree. We cannot continue using COVID as an excuse for not having done the work. Yes, it did in some instances impact us, but as correctly identified and picked up by the honorable members of the Portfolio Committee, I mean, the reports we're delivering today, the actions many of them come from way before we even experienced COVID. So we do take that point that we cannot use COVID as an excuse for not achieving. But where maybe it has impacted us, we can highlight so. But looking at the reports and how far back they go, it's not necessarily the case. I think that the point that was specifically made around COVID was in relation to how it affected the completion of the work that was being undertaken by the AG. That's why the AG started the work in 2019 and the AG was supposed to finish in 21-20, but due to the position that they had taken in terms of their work arrangements, then the audit took long. I thought I should just clarify that, but also agree that from a department point of view, we cannot use COVID as an excuse, Chairperson. There was a point that was also raised around by Honorable Malinga around the issues of the systems not working. Chairperson and members, we do as a department, we have a very obsolete IT system. And I think even the challenges that were mentioned today in the meeting where people could not fly presentations is part of that, but it could also be as a result of load shedding, specifically today. But we have an obsolete IT system that at times is not compatible or it affects integrating other systems. We are working on upgrading our systems and getting them in order so that they do not negatively impact on other systems that are critical, specifically for the work that we do and for service delivery. Then there was a point that was raised by, I think it was by Honorable Matoko under the ESM around the strategy. Why did we not have the strategy? I thought I should clarify this. We've always had the strategy. The issues raised by the AG has to do with the implementation of the strategy and the shortcomings of the strategy. So the strategy has always been there, and it is what has been guiding the work that we've been doing around the rehabilitation of the mines. The other question that I will respond to is the one that was raised by Honorable Volmarans around the possibility of redirecting funds. Honorable Volmarans, I think in one of the presentations that we've done to the committee, we have indicated that while in the beginning, the whole allocation for ownerless and derelict mine, we were directing it towards rehabilitation of prioritized sites, which is mainly asbestos sites. When issues of safety initially became an issue around abandoned sites, we then redirected a portion of the budget towards closing the holdings. The holdings program, it's not closing the holdings program only in asbestos mines, but it's also in some of these problematic mines. And even the prioritization that happens now by Mintech and the department takes into account where we have a problem with some of the illegal mining activities. So within the limited budget, we try and reprioritize to where some of the challenges may be. And then there was a point around limited monitoring that was raised by Honorable Matokwe, and vacancies, and I think the point that the colleague was raising here around resources was more around the fact that if you look at the number of sites that we have and the work that we'll have to do, or the number of times we'll have to go to site and do the monitoring, there is not sufficient home bodies to deploy, and this is the case. we are also in this regard limited, obviously, by the allocations that we get from National Treasury. We are currently reviewing the department structure, and I have to say it's not only in this area where there are challenges in terms of the resources. I think in your comments, Honorable Dog, you also mentioned the issue of I think it may have been even Honorable Malinga around empowerment and communities and assisting communities. I mean, even just on that front, in terms of community engagements and stakeholders and making sure that we get involved in resolving the disputes, we are very thin in terms of the home bodies. So we are looking within the department as part of the measure, finalization of the measure, to see how we can move people around and arrange ourselves to optimize the resources so that we can cover all these areas. But there are other things that we believe that we should be looking at in terms of using technology. I think the presentation that was done by CGS previously, where they showed how you can use satellite images to monitor what is happening on the ground and have a sense of if there is a challenge that we should be attending to. So those are some of the things that we are looking at as a department as part of the restructuring that we are doing. I will now, Chairperson, with your permission, hand over to first the DG Makobela to respond to the questions that were raised from the presentation that he made, and then he will be followed by Chief Director Mwatsi on the presentation that he made. And then if there are any questions that have not been covered, I'll come back on those ones, Chairperson. Thanks. DG Makobela.
Thank you, DG, and thank you, Chairperson and honorable members. Firstly, the questions and comments from Honorable Malinga on the issue of local beneficiation. It is true that what we found is that there isn't a dedicated, a focus on what we call host communities. And I think part of this, in our view, is historical. We've seen this as we engaged in Northwest, for example. And what we then agreed in a tripartite structure with communities and the mining houses is that as contracts expire, because there is the issue of there's an existing contract with somebody who's coming from, let's say, another province. We said you can't abruptly just terminate those contracts. Then we said, as those contracts expire, the existing one, then you need to begin to look at host communities as priority for the replacements. So those programs now, I think, are beginning to take root in the different host community areas. What we found, though, is that in general, the mining companies are their strategies for communication are ineffective. They are there, but we don't think that they are effective. And we've said that in bilaterals with them to say that they need to go back to the drawing board in as far as, particularly engaging your host communities. On the issue of on the MPRDA, perhaps, maybe I was not very clear. We indicated that we have identified gaps on the MPRDA, particularly as it relates to illegal mining. There are gaps, for example, unlawful possession is not criminalized in the Act, unlawful transportation, and all of that. I think those are areas that we've already identified that are being worked on in the amendment. Then on the issues raised by Honorable Madokwe, I think the issue for me with the Human Rights Commission is that, you know, the presentation tended to go from, yes, unregulated, but very quickly moves to illegal mining and tries to equate the two. And we thought that artisanal mining in particular, I mean, there's a particular approach to artisanal mining, and you can legislate for that. But when it comes to illegal activity, in our view, there's got to be a particular heavy-handed focus, that because it is bordering on, in fact, it is economic sabotage, what is happening as a result of illegal mining. The issue of profiling, SAHRC is profiling, in fact, has profiled the different levels. And there are 5 categories that have been identified in that profiling, including then, of course, those who do the trading. And in fact, they brought a specialized, a syndicate fighting unit to basically focus on the top level and not just on the foot soldiers. So there are some cases that are being followed up in terms of that. The National Coordination Strategic Management Team, the members of that team include the SAHRC itself, DPCI, this is now the Hawks, intelligence. Of course, we participate in that ourselves. Department of Justice, this is now the prosecution authorities. And effectively, this is a structure now that has recommended what the DG of Mineral Resources and Energy, DG Mbele, and the National Commissioner will be signing off on. So that team, has recommended that there must be a multidisciplinary team that is going to be focused on this, and that its operational model has also been finalized, and it will include this time Home Affairs, and again DPCI, but also the Diamonds and Precious Metals regulator. There will also be a dedicated prosecutor who will be working with us, the Asset Forfeiture Unit, as well as regional staff of the department will also be involved in that. So there is an effort to really formalize the structure that is going to tackle illegal mining. On the issue raised by Honorable Volmarand, again, I think it was more on the profiling issue. I think as I indicated, I guess our understanding of profiling is that is a specialized skill, and it then begins to categorize, who gets involved in all these activities. And we think that already that profiling has been done by SAHRC effectively on all the provinces where illegal mining is taking place. And then I think what what I would also indicate is that I think based on the presentation by the Human Rights Commission, it is true that we have to now go back and engage directly with them so that these differences, we can, try and explain ourselves. I don't think they know how far we've gone since they did the work that they did. And one of the things that is holding us back is that the announcement on this new unit and how it's going to operate is going to be made by the Minister of Police. And before that is done, we can talk in general, but the specifics we cannot go into until that launch is done by the Minister of Police. I will stop there. Thanks, DG. Thanks, Chairperson.
Thanks, Ntate Makobe. Ntate Moatse.
No, thanks, DG. I think most of the questions have been addressed by the DG. I'll respond to two or three of them. The first one, it's from Honorable Madokwe, which says that Mintech had offered to help the police in relation to the work on mining or rehabilitation and so on. I've indicated in the presentation that Mintech is part of the national coordinating management team, and in that forum, amongst others, I'm aware that Mintech's role also have been to share some of the expertise in terms of mining work, which is being done. So they are part of the committee, and they have been assisting them in this regard. Yes, indeed, you will recall, honorable members, that amongst others, the Mintech had also offered to assist in terms of development of a system more like your satellite system. And that has been also acknowledged by the police in this instance to address the issue of illegal mining. So I must indicate, Honorable Chair, that Mintech does play its role in this regard. The second one, which I want to talk to Honorable Chair and Honorable members, it's related to the database. The question is, what is the expected date of completion of updating the database? The AG identified gaps, and what we are doing right now as a department in the current financial year, that is 2022 ending March 2023, it's basically to complete these gaps which have been identified. So colleagues are actually going through each and every file of the area which has been rehabilitated and filling up all the necessary information which is expected. And then the other question related to derelict and ownerless mines. So is there a plan to follow up the owners of these derelict and ownerless who may be present in the country? In the development of the inventory, derelict and ownerless inventory, which resulted in the database being developed, part of the brief to Council for Geoscience in this instance was to follow up the mine right holders who may be present in the country or outside of the country, who would then be liable for this exercise. So that work was done, and the information which we have since received is that these then become the ones which have been identified become the liability of the state in terms of the legal understanding of what would then become the derelict and ownerless mine. So that has been done. There was a mechanism to follow up all of these mine right holders. Without hiding, I think there was a concern which was raised by honorable members, Honorable Melinga as well as Madokwe, about the hiding behind the COVID. I do note the DG's comment in this regard, but I also want to indicate that in my first slide, you will note that the audit was to be completed in 2020, March 2020. And because of that, actually the Auditor-General suspended the audit, let me say extended the audit to cover to flow into the following year. And one of the things which we had to do as a department in terms of the migration of this database was to train the officials. Now, part of the training of the officials is to have a physical interaction with the system itself. Although I do understand that during the COVID, there was also a system, MS Teams and so on, which we could also use. But these were some of the challenges where we needed to have a physical contact with the software itself. And that is why some of these things were done as part of the 2021-2022 financial year work. The next question is related to the delay of the National Mine Closure Strategy. Why the delay of the National Mine Closure Strategy? Honorable Chair, I have indicated that in 2013-2014, and I think part of 2015, there was an intention to come up with one environmental system. And part of that work, as indicated, was to migrate a portion within the legislation, within MPRDA, to the Department of Environmental Affairs. And amongst other things, I must also indicate that in developing the National Mine Closure Strategy, one of the thinking behind the strategy is to develop what we call economic succession planning. Now, to develop economic succession planning, in other words, ensuring that when the mine closes, the economic development in that particular area is sustained. You need to develop mechanisms to do that. One of the pillars of this economic succession planning is what is having to re-look at the environmental management plans of existing mine right holders. Now, it therefore called, that is why there was this delay for us to be able to look at this migration. What would it impact on the National Mine Closure Strategy? But I do understand the concerns which have been raised by members in this instance. And I think that would be the last questions. Otherwise, others have been answered by the DG. Thank you.
Thanks very much. Okay, before I hand back to you, there was a point that was raised around or a proposal around the fact that there was a question first around any bilateral meeting with the Human Rights Commission. I'm aware that there was acknowledgement in writing of the report when the report was published. And based on the comments that were made today, and we will definitely, from the department point of view, reach out to the Human Rights Commission, share with them our observations in terms of the issues that they've raised, and make sure that there is a common understanding of the issues. from both from our side and also from their side. There was also I'm just quickly trying to go through my notes. There was also an issue that was raised around the fact that we cannot negate some of the issues that are raised by MACUA and WAMUA, and there was a proposal that we should sift through the issues and work on the genuine issues. We will definitely do that, Chairperson, as it was also indicated that some of the issues they are raising are actually issues that have been raised by many of the general community members. And then just trying to go through, and we've also noted, and excuse the pun here, we've also noted the point that Honorable Vomarans made around some of our responses on the AG's report, indicating that we are noting, and I guess here these flow from when one looks at the detailed report. Some of these in the background, there are specific recommendations that the AG is making, and what I'm getting is basically for us, while we're saying we're noting them, we must be very clear what will be the exact next action, and we'll definitely do that, Chairperson. I will stop here, and maybe if we've missed any of the questions, we can come back to them, Chairperson. Thank you. Over to you, Chair.
Thank you, DG. You made my work a bit easy. I was going to raise some of the things that you are raising. Look, first, let's agree. The Department of Mineral Resources and Energy is responsible for the minerals beneath and even on surface, by the way. That's how we understand it. You are custodian of the mineral wealth. Now, you, as custodians, when something wrong that tampers with those minerals, your custodianship means you must be the first complainant. And as the first complainant, I can imagine if you were to go to a community and they say, we've got a problem, Yamakinza. And they say it's not our responsibility, it's the responsibility of police. I don't think it would be a good argument. They should be the ones that says, you want to set up a community policing forum. We want to have the police monitoring maybe 2 hours, after every 2 hours or 4 hours. We want to do 1, 2, and 3 because they are taking responsibility for their lives. So DMRE can abdicate its responsibility to protect and defend the mineral wealth, including against those who are conducting such activities in an illegal manner. What police are supposed to do is to effect the recourse that they have as law enforcement agencies. So mobilizing law enforcement agencies is a responsibility of DMRE in protection of their own responsibility on the minerals on behalf of the people of South Africa. So I'm happy with that we are getting back to accept that we have got a duty and a responsibility, and that duty includes assisting the police to perform their duties in a much more effective manner. And therefore, that becomes a plus on yourselves. That's point 1. Point 2, I'm happy that you are addressing the issue that it has been a concern for me, but let's also go back and agree that DMRE never closed, and I can tell you why. And the minister had always been raising this thing. By level 5, level 4, was at level 3, you were the ones as DMRE who were saying which sectors of the economy can't close, which sectors of the economy must close, Good sector. We cannot then say that the DMRE was affected by COVID, even if we were to say during COVID, because amongst other issues, it didn't mean because there was COVID. In fact, the DMRE, if we're to follow that argument, lost an opportunity to effectively deal with the issue of illegal mining at the time when we were seriously under COVID, strict COVID regulation. But let's leave that and put aside. The truth of the matter is that that issue that is being raised both by the Human Rights Commission as well as by the AGSA is more of a legacy matter. It's not something that they are raising it for the first time now. And I'm happy for me that you say you are going to engage with them. So I want us to agree on this thing that the DMRE, we have initiated the two Chapter 9 institutions have raised issues of concerns. You don't have DG even to be in the meeting, neither the minister or the deputy minister. I will ask that exactly what you say, take out a delegation, let it go and listen, engage with the Human Rights Commission, even if it's separate delegation, engage with the AGSA, especially during the moments and periods of audit, and then come back and report to this committee. All what we want from you is a commitment as to when can we get the report back. Two, I'm worried, I'll be honest with you. I was worried when you did not ask from this committee how you should respond on the issues raised by MACUA. You intended, and I'm not saying this in a negative way, you intended to address the committee, not the issues raised. And I remember when you say then you will go back, Honorable Matoke puts it, at times we don't like the way that they are engaging with us, but there is only one thing that we have taken as a committee, as a matter of principle. No issues where we still have got a chance and an opportunity. No issues will be raised about this committee and we don't listen and we don't apply patience. So that if we disagree with people, we must know that we disagree with people because they expect us to go beyond what is expected of us in terms of the founding rules of Parliament on the establishment of portfolio committees. It is not personal, it is not in it. So we want to appeal to yourself, apply some degree of patience. Deal with people, agree that you don't, for instance, when they write some of the things, we can't tell you what to do, but when they write some of the things, they have got something that is a record. How can a department expect that it can write back and have records? That this one is impossible to do because of 1, 2, and 3. Can you go back? What Mr. Makubela was raising on MACUA WAMUA, can you put it in writing? Let me make an example. They want to be part of, they want you to tell them, which is the same thing. When you do take particular activities, you must inform them. They want to participate in RAMDEC. That is you. You must then be able to put it in writing. We can't allow them to participate in RAMDEC because of 1, 2, and 3. For instance, RAMDEC is about community participation, not representatives of communities to participate. I'm just making, I don't think it's such a difficult thing to do. And then you bring it back to the committee. And if it needs be, like you say, invite them, sit down with them. You must know which areas of disagreements that you are disagreeing, and then they have got a duty or they've got a choice of what then the next step that they are taking. But be careful not to disagree with people simply because you allow attitudes to flow up, that this is how they behave, this is how they do things, and therefore we're not. You must be able to say, when this committee invites you, Chair, we met with them. They want this, we can't grant them because of this. They want this, We can't grant them because of this. Yes, we agree on this one. This is what we think we can work and cooperate with them. We want to see them as more complementary to the work that we perform as a department. They assist you even with regards to the non-performance of your own colleagues in the administration. But the manner that, for me, my fear is that you were prepared to give a formal and official presentation on the two Chapter 9 institutions, but not them. It then makes you to be the same like them. So I'm happy, and I will encourage you. We are still having our own issues with them, but we are engaging them. Obviously, there will be a time where in our engagement with them, we must draw a line. Let's agree here, we don't agree. You will do what you feel you need to do. We will have to decide what to do to protect the integrity of Parliament. But we can't just ignore and say, no, what they have written. You don't necessarily have to address us. Yes, address us, but address their issues through us. But you don't have also to avoid engaging them. Engage them. You except if your ideas are not superior. There are things as a state institution or as a state component, they may not be able to happen. For instance, you must explain, you must enter, there is issues that they were raising around that every time there is, even from us, there is a public hearings, they need that the transport must be given to them. And it can be explained. Ours is simple. Parliament engages communities. It doesn't engage representatives of communities. And therefore, every transport that goes out, it goes out to the community. You can't select and say it will be for so and so and for so and so. Otherwise, once you make Parliament a structure of recognition of structures or representative structures, you run the risk that everyone will stand up and say, but why are you recognizing this, but you are not recognizing that one? That's how, and I'm saying we may not all share the same views. We may differ on what has to happen, but that's the reality. That's what it is. So until such time you agree and you are able to point out on areas where there is a disagreement, you will not resolve this thing. My last point is what honorable members were saying, and unfortunately I'll have to say it here at DG because we have never had an opportunity to engage. Part of the things that we've raised as concerns in the department, Honorable Malinga is correct, is SAHRC. We look at the presentations that have been made, even when your first, second, and third quarter report, which were the issues I was raising. If you put in 37 mining rights in a period of a year, let's just take a quarter, how many applications do we get? So the question of data collection and performance of task still remains a problem. That includes some of these things. My request to you, DG, tighten up the screws. You need, once you are appointed as a coach of a team, the moment you allow certain players not to come to practice, well, even if they don't perform because of their household names, even if they don't perform, you keep them on the field. I can tell you, you'll never have a winning team. My request from you is that from the start, things must change. This department, it depends on you, not on the executive authority. Government can run, even if politicians like us are not there. It has been proven in 2008. It was proven that whether executive goes, but yourself as part of the accounting officer team of government, crack the whip. That's my only appeal from you. Push your administration. People must perform their duties. Improve on the technology challenges. If you don't improve on the licensing regime, if you don't improve on data collection, if you don't improve even on revenue generation for the department. The more, for an example, you get, it may not be relevant now, just sharing an example. The more we get people into the mainstream of our mining performance, the more mining rights you give, the more people get opportunities for investment, the more exploration is done, is the more revenues being generated and more our economy is growing. And once the economy grows, then that's when you start also to, not saying it is a condition, but it's the more you then have to justify why then you don't grow, is not absorbing employment. So the more employment opportunities are prevailing. So that is my request, DG. Try and make it a point that zonke inkabi zakho ziyadonsa. Mazingena entsimini asilime kubonakala ukuthi sisentsimini manje. Before then I could go to the next issue. Do you want to have your last comment because DG? And then we will go to the adoption of the report of Jagersfontein.
No, Chairperson. From my side, I take your comments, and we, as I earlier indicated, we note and take the comments from the committee as well, and we'll definitely reach out to the presenters that came and presented to the committee, and at an appropriate time, we'll then provide feedback to the committee. We will endeavor to do this within the next 2 months, Chair, from a commitment point of view. Thank you.
Can we get a progress report end of November?
Yes, Chairperson.
Okay, thank you very much. You are released and relieved, but you can stay if you want because it might be a matter that affects you. Honorable members, I saw Babunte-chan. You know, when you see a lawyer, you must know there might be something that requires your attention. Should I give Mr. Ntechana first?
Well, here, Chair, if you want us to proceed with the meeting, we can, Chair.
Please, because we want to adopt the report. I know that there was an issue initially we requested from yourselves with regards to the disciplinary case. Maybe it will help if it is about that. But any other matter, before we go for adoption, the floor is yours.
Okay. Good morning, Chairperson and honorable members. Chair, I'm assuming that the reason that you have called us is because of the letter which has been addressed to the committee by the Minister of Forestry, Fisheries and Environment, dated the 3rd of August.
No. I think. Okay, no. We will come back to that one. No. Arining motion, then I under. We said when we deal with the bill itself, can we first deal with the report of Jagersfontein? Sorry, Mr. Tejan. Ari?
That's fine, Chair.
You were flighting that report. Yep. I thought they wanted to further give advice on the disciplinary case against the employee who addressed the portfolio committee. Are there any...
Chair, just to indicate and highlight to the members that the correspondence was sent off to Jagersfontein Developments yesterday, and we've sent a copy of that letter to the members as well, Chair. They haven't acknowledged receipt yet, Chair. The what do you call it? The gentleman, he confirmed that he received the Chair, but Jagersfontein Developments haven't confirmed receipt of the correspondence, Chair.
Okay. I want Tejana to come in there because we might have, but let's deal with the report first and adopt it so that we release other members. And let me appreciate those members who joined us, even though they were in other committees. We really appreciate that. Yes, let's go to where there were corrections.
We'll go straight to the committee observations, Chair. Chair, this report was sent yesterday to members as well. The changes and amendments are in yellow, Chair.
Okay. That's bullet point 1 in yellow. Bullet point 2 and 3. Okay, bullet point 4 and 5. Bullet points 6, 7, and 8. Shouldn't we have a big N, what do you call it, NB? When my teacher used to tell me, used to say nota bene. You see? Okay. Can we then go to the recommendations, bullet point 1? What is including other? Because it's correct where it says including the tailing dams. Then why including other? Let's take out the including other. Yes. Let's grasp bullet point 1, bullet point 2, a broader. No.
Chair, you will just see here that we've indicated by when.
No. It can't be, it's not to our committee. I think it's not the department. It's the Committee of Water and Sanitation. And I think we said report back to Parliament. Yes. The only thing I'm not sure, didn't we put a time frame?
No, we did not, Chair.
Do we need to put a deadline there? Will it not be too prescriptive?
Yes, Chair.
So I think we must just say report back to the National Assembly on a time frame that will be so determined. Yes?
If we leave it open-ended, Chair, what if we encounter another Jagersfontein incident? I know it will sound prescriptive, but this is an urgent matter, Chair.
Yeah, but what I'm saying, that will be too prescriptive to another committee. It doesn't account to it, to us. Maybe we can say to the National Assembly, as required by,
Matter of agents, Agna time
yes,
frame.
Maybe, yes, as a matter of agency. Yes, you are correct. Sure. I think this one is not for us again, the PC on social development.
Where are we now, Chair? Oh,
I
this
think
one.
that's what yes.
That one, Chair.
Yes. I think that's what we said. We said the PC on social development must show that there is urgent psychological support. That urgent psychological support is provided to the affected communities. No. The PC on social development should ensure that the Department of Social Development
Development, Department of Social Development. That's fine. I'll sort that one out, Chair.
yes. It's not SD, DSD.
Provides.
Hey,
DSD.
thank you there to the English teacher.
This DSD, not SD. The PC on DSD.
On social development, Chair.
Yes.
Social development.
Oh, yeah. Oh, DSD is a department. Yeah, correct.
This is the department.
Yeah, DSD is the department. Okay. I think the rest are correct.
Provide investigation, Chair. The next point.
Huh?
Are we not leaving it to the second point, the following point? Who conducts the investigation?
I thought that was government. No, not DMRE, because we said these entities are not under DMRE. It will be government. Conducts an
Preposition should, government should conduct an investigation.
Yeah.
Yes. Beyond, isn't supposed to say beyond Jagersfontein instead of outside. Yeah, no, that one we agree. Honourable members, there is the report. with the corrections that we have just done or whatever, which are not major. Can I get a mover? Honorable
Chairperson.
Malinga. Yeah, Honorable Van Marans.
Chairperson, I move for this report to be adopted as a reflection of what transpired during our visit, Chair.
Okay. Any second? Are you seconding, Honorable Malinga? I saw your hand.
Yes, Chair. Seconding the mover.
Thank you very much, honorable members. The report is therefore duly adopted. Thank you very much. Is there any other matter? Ari?
Are we going to deal with the minutes? Someone out, Chair?
You want us to deal with the minutes? When are we? Why? Myself, I'm a bit. They call it in Afrikaans,
It's Friday, Chair.
It's Friday. I understand. Hey, this committee works like nobody's business. What are we dealing with Monday, Tuesday?
Tuesday, ESCOM, Chair.
It's a joint committee.
Joint committee, yes, Chair.
Okay, let's deal with the minutes very fast. A bit patient, honorable members, who are almost done.
It's 13 September, Chair.
Yes.
Tuesday's meeting.
Yes, those one won't be different. Down. Yes. For we're dealing with 4. If there are any corrections, 5. Okay. On that note, is there any mover?
Volmarans, Chair. Chair, I hereby move for the adoption of the minutes, Chairperson.
Thank you very much. Any second? Any second?
Okay. Second, Chair.
Thank you very much. Is there any other set of minutes, Ari?
Yes, Chair. That of the 20th, Chair. This past Tuesday.
Yes. Kanos Jeresin.
I'm getting the minutes now.
Okay. One. Let's go. 2, 3. 4. Go. 5. 6, 7. Is there any move of the minutes?
Mr. Chair, I've got a suggestion on the minutes.
Let's first move or accept if there's a correction.
No, I want to make a correction, Chair.
Yes, Honorable Lorima.
Page 3, bullet point number 6, with regard to backlogs. The DMRE stated that they've made significant strides with regard to the backlog on the mining side, and there's no backlog on the petroleum side. You remember, Mr. Chair, the DMRE also promised to update us on these figures. I'd like to capture that in the minutes.
Okay. What type of a dog is that one? It sounds like a pit bull.
German Shepherd.
Oh, I know dogs. Okay. Is there any other matter of corrections on the minutes? In the absence, is then there any move of the minutes with the corrections made? Any mover?
Move, Chair, with the additions that Honorable Lorima has just made. Thank you.
Okay, any seconder? We'll sleep here looking for a second. Any seconder?
Chair, I thought Honorable Lorima would second because he has made an addition, but I second.
Okay, thank you, Honorable Volmarans, with the second. Any matters arising? Okay, no matters arising because everything is in a program. Honorable members, is there any other matter, Ari?
Noted. Does the other item was now on the UPRD, Chair?
Yes. When?
Now, Chair.
Yes.
So do you want Andile to come in, Chair?
Yes.
Sure, Andile.
Good morning again, Chair, and the honorable members. Chair, I'd hoped that you would give some introductory remarks regarding the letter itself, but I know that perhaps the committee is well briefed on it. Chair, can you hear me, Chair?
Yes.
Okay, thanks, Chair. Chair, I'll cut to the chase, as you said, it's a Friday. Chair, firstly, this letter, Chair, it in a way, Chair, throws a spanner in the works, and I'll tell you why, Chair. Firstly, Chair, as you know, this is an executive bill and not a committee or a private member's bill. Now, as you are aware, Chair, committee bills are processed differently. And just to draw a baseline concerning ministers and departments making submissions on bills before Parliament. And clearly in those cases, Chair, there is no cabinet process. Hence, the rules provide for such consultation by the executive in the case of committee bills and private members' bills. Now, Chair, this matter should have been resolved at cabinet level, Chair. Now, if you look, Chair, at page 57 of the bill itself, particularly on the memorandum on the objects, Chair, it says the following departments and statutory bodies were consulted on the bill. It lists them, Chair: Department of Trade, Industry and Competition, National Treasury, Onshore Petroleum Association of South Africa, Offshore Petroleum Association of South Africa, Petro SA, SAHRC, and it says the bill was further published for public comment. Now, Chair, the first question about the desirability of dealing with the bill now is why there was no mention of consultation. with the Department of Environment, Forestry and Fisheries on the bill. We feel that, Chair, there should be a clear answer as the bill has been through Cabinet. Secondly, Chair, the committee should consider whether it is desirable to have the Department of Environment, Fisheries and Forestry and its minister making submissions and taking time off the committee that is in fact meant for public participation. Again, Chair, we feel that ideally this matter should have been resolved at Cabinet level. The committee, Chair, should discuss whether this bill is ripe for processing, given the deficiency that this matter has caused. We're of the view, Chair, that the minister must account to the committee for this. And I think, Chair, in short, our view is that the minister should account and take the committee in his confidence about the letter and the apparent deficiency or deficit in processing the bill at Cabinet level. So that is our view, Chair. I'll leave it there for now. Thank you, Chair.
Yo, honorable members, any take? I see the end of Mayor Malinga.
Thank you very much, Chairperson. Let me welcome the advice given to us by, I don't know whether he's an advocate Jagersfontein. We welcome it, Chair. We don't want, as a portfolio committee of Parliament, to be dragged in the cabinet issues, because both ministers sit in that structure. So, Chairperson, I think he has outlined the process of which I think DMRE has followed to the latter. But I would also concur with him. I think when he says the minister should come before the portfolio, he means the Minister of Forestry and Fisheries. I guess azositshela ukuthi uhlulwa yini ukuyokhuluma nogwethu. So that's my take, Chair. Thank you very much.
Is there any other member? Mr. Ndejana, can I ask this simple question? Is it a matter of either or it's only one option? For instance, a committee, if it is satisfied itself that its own procedures and processes are correct, do we have to entertain, or should we do what you eat? Because the starting point of the advice says, if we are satisfied, I just paraphrasing, I'm not saying that's what you said. If the committee is satisfied that all the processes have been followed, and this is a member of the executive who would have been part of the processes, and in terms of what is in front of the committee is a proof of consultation that had taken place, which unfortunately the letter does not dispute. I'm trying to check now, is it a matter of, because one might argue and say, if you invited the Minister of Mineral Resources, but that minister has not written any letter to the committee to say, I've got these misgivings of what I gave you, and you don't invite the one of environment. If I say the minister of DF, I only realized later, Honorable Mato, that there's a DEFF. But if the minister is not invited, then there may be a case that I wrote, but also these are the two individuals. When it comes to the separation of powers, these are individuals that are in the executive, and one would argue and say the matter should have dealt with at the level of the executive, yes, at the level of the executive platform, which is cabinet, and that's what it codes. So I'm not sure. That is why I'm saying my dilemma is it a matter of either or? Because if it's a matter of either of the two, then it might be easy to say, look, as far as the committee is concerned, this is a matter that should be addressed at the level of the executive, except if it was coming from our sister colleagues in the portfolio committee. For example, I'm not sure how can a committee of parliament intervene on a matter that is in front of the executive, simply because our sister, what do you call it? Our sister committee would have made something that we believe is not a reflection of what we talked about. Just please clarify this thing, so that I think that's what Honorable Malinga is also trying to say we're grappling with, is that these people have got a platform of their own. Aren't we now taking over an executive function of managing differences of understanding by the executive? Can you help on this thing?
Yeah, Chair, I'm not sure whether I was emphatic enough, Chair. I think the point I'm making, Chair, is simply is that this matter, Chair, resides with the executive, and as correctly as we have captured it at cabinet level. Remember, Chair, this is an executive bill. So naturally, all we're saying now is that just from an angle of practicability and effectiveness, Chair, we're saying that now you have a committee of parliament, Chair, which would be seized with wading through public submissions that it has received on the public participation process. And now, Chair, we find ourselves being entangled in a matter that resides in another sphere, which is cabinet, which is the executive. So that's why I'm saying, Chair, I mean, if the committee really wants to make progress regarding this, because the assumption, Chair, is that once it lands on the committee's desk, Chair, is that there's been some unanimity between these two executives. So all we're saying, Chair, is that we find it anomalous that a document, Chair, that comes from cabinet where these two executives sit. Then when it's in parliament, then you find a letter from another one saying, no, these are some of the things which this bill should look at. And if you read the letter, Chair, it's written in a way as if the other one was not aware of what was happening. So in other words, it's a question of the right hand not knowing what the left hand is doing. So that's what I'm saying, Chair. The committee, I mean, in terms of its rules, has got it has a leeway, Chair, in terms of how to deal with this regarding its processes. But our view, Chair, is that why should the committee be settled with that, Chair, when this matter resides in the executive? Thanks, Chair.
So does
Chairperson?
Yes, Honorable Mahlaule.
My apologies, Chair. Greetings to everybody. I just wanted to ask from Mr. Techana that would there be a need for us through the Speaker or Chair of Chairs to write to the leader of government business, making them aware of this entanglement that the cabinet wants to put us as a committee of parliament to, and show our non-interest in the entanglement. Thanks.
100%, Chair, 100%.
So does it mean now, can we go to the real issue? Where are we now, Ari?
We were supposed to adopt the motion of desirability, Chair.
Okay. Any take, honorable members? I was told, I think in the last one, that there are two options. We deal with it now, or if we feel that only when we come, because we can only go for public hearings if we adopt the motion of desirability, or we want to consider the motion of desirability post the public hearings. Those are the options, or we agree that the motion of desirability can pass as undesirable, and therefore we don't proceed with any other thing, it ends there. Then there will even be no reason to invite the department to come back and make next submission. Can I get a proposal? Do we take it? Which one of the three do we take? A motion of desirability now, or we agree to go for public hearings to get more and be more informed, and then do the motion of desirability, which I think it is, in terms of what I read on the rules, it allows, or we take the motion that the bill is not desirable. Honorable Matobe.
Thank you, Chair. I did actually get cut off because of network a bit, so I did miss most of the thing on this. But also I had realized that there were some documents that were shared by Ariko, I think this morning, if not yesterday. I think it was written submissions, but we've not really had an opportunity to peruse those documents because of when they were sent. I hear that there's a suggestion of perhaps us looking into public hearings. And I was going to maybe suggest that maybe instead of public hearings, we just maybe try to go through those written submissions so that we do have an idea of what is being proposed to us and what the public, with what has been submitted through written submissions, has said. And then from there, we are able to give a response as opposed to actually starting public hearings altogether. And maybe I was going to suggest if we can maybe then by Monday, so that by then maybe we would have had enough time to peruse that, then we can just put a quick agenda item for Monday where we can just conclude whether out of these three options that the chair is suggesting, which ones we will go with. Thanks, Chair.
Okay, Ari can correct me. You can't deal even with those written submissions. Those are written submissions, but you can't deal with them if you adopt the motion of non-desirability. For starters. Two, the written submissions, you can only entertain and deal with them after you have conducted public hearings or before you conduct it's not separate. If you allow them to come now on their written submissions to make oral submissions, it means it's part of the public consultation process. It's only separated into two. It's physical public meetings. Two is to invite people to speak, those who want, because others can just deposit submissions and not want to make oral submissions on their written submissions. So it's not either or. We don't start by hearing those who have written. Otherwise, we are disadvantaging those then who may not have access to emails and other things. Am I correct, Ar? That is the only snack that we will have. And if we agree that we adopt the motion of non-desirability, there is no reason, no need then for us to consider even public hearings, including the written submission. Am I correct, Ar?
You are correct, Chair. So non-desirability, then everything stops. I mean, Andile can confirm that as well, Chair. Look, with the guest amendment bill, what we did was the committee proceeded with the public hearings. the provincial public hearings, and then we had the written submission, oral submissions meetings, and then we adopted the motion of desirability, Chair. But as Advocate Jenkins said in the previous meeting when we dealt with these issues, Chair, the legislation is, or the rules are not that prescriptive, Chair, with regard to the motion of desirability. So I don't know if
but I think the point what Honorable Madog is raising is saying, let's take the written submission, call it oral submissions.
Yes.
Then based on that, we make a determination. I'm saying my understanding is that the oral submissions are made, are given a specific time to submit in writing. After that, even if you then have to agree, if you say, for instance, we'll adopt the motion of desirability after public consultation, it includes both, not one of the two. It includes both the written submission and the public hearings. That's what I thought for me, you can help us on. Can we do and say, okay, fine, we'll only do the written submissions? Because the written submissions, Honorable Madog, that's how I understand it. It's not us reading the written submission. It means those people who have written, we will have to check from them who are the ones who want to talk to their submissions. Now, in that process, then it means we are locking out those who are supposed. I'm not sure how will that then come in as far as the role of a committee of parliament in terms of public consultation is concerned. That's what I thought, you can clarify in Mr. Techan.
No, Chair is right, and I think you are right as well, Chair. Because if you read the rule, Chair, I mean, Rule 286, for instance, of the Assembly, you will see that there's no clear delineation between whether you do it before or after. But I think, Chair, for practicability, and I use this word, Chair, very advisedly, is that because remember, Chair, this process requires deploying resources. Why should a committee chair not upfront pronounce on its attitude regarding whether they feel the bill is desirable or not? I'll end it there for now, Chair. Thanks.
Okay. I see the end of Honorable Malinga and then Honorable Madog.
Thank you, Chair. I think there is desirability for this bill, Chair. That's what I wanted to say before all the rhetorics were said. Thank you very much.
Is there any second to the view of Honorable Malinga?
Volmaran's Chair. I do second the proposal through Honorable Malinga, Chairperson.
Okay. Is there any contrary view? Going 1, going 2, going 3. It then therefore means that we adopt the motion of desirability. We will have to go for public hearings as well as now welcome the written submissions. Can we then ask the committee staff to start to prepare the program so that we can present it to the committee maybe before we close next week? One, the program to deal with the written submissions and also to deal with public hearings. That's what will happen because we agree on the issue of the motion of desirability. Is there any other matter, honorable members? And Ari?
Recording stopped.
Ari left still. Ayanda, are you still in the house? You'll have to speak even if you're on the road.
Yes, Chair, I'm in the house.
Okay. Can we now declare the meeting adjourned?
My apologies, Chair, I was cut out now.
Okay, honorable members, the meeting stands adjourned until next week, Tuesday. Thank you very much, including for your patience. Thank you very much.